Hi, Jem.
Hi, Ansam.
What is the competent authority under Swiss law that's testing the validity of an arbitration clause? Is it the state court or the arbitral tribunal?
Well, under Swiss law, the easy answer is that the arbitral tribunal or the arbitration panel has authority to test the validity of the arbitration clause. And, let me demonstrate you how it works in Switzerland by a particular scenario. So let's assume you have two parties that have a contract that may or may not have an arbitration clause. And for whatever reason, the claimant is filing a claim with the state court, and the respondent or defendant is raising the defense of lack of jurisdiction to hear the claim before the Swiss state court. What the state court usually does is that it runs an assessment on the basis of, let's say, summary proceeding and an expedited summary process where they just run a prima facie evidence where they are testing the arbitration clause on its validity. So if you have prima facie evidence that clearly demonstrates that the arbitration clause is invalid, the state court will decide that the arbitration clause is not valid. But in every other circumstance, like, if there is whatever reason to object against the state court's jurisdiction to hear the claim, the court will just run a very brief summary assessment and on the basis of a prima facie evidence. And if they are of the opinion that it is not really clear whether the arbitration clause is valid or not, it usually sets a deadline for the defendant to file a notification or a notice of arbitration. And then it's going to be the arbitration court or the arbitral panel or the arbitral tribunal who will test the validity of an arbitration clause. So, in general, I would say a fair summary under Swiss law is that in disputes where an arbitration clause is at stake, it is the arbitral tribunal who has authority to test the validity of an arbitration clause under Swiss law.
Thank you for this.
See you soon.